Joining us now is criminal defense attorney Ashley Merchant and Anahita Sedaghatfar. Let me first start with you, Ashley. Why was he convicted? The defense claimed that, it was the castle law, the castle rule, in fact, that it's his home. Right. They believe that it was being encouraged, there was an incursion illegally by this teenager, and that he was in his rights to actually tragically kill this young man. And
absolutely. That's my sense. I was actually surprised that there was a conviction in this case because the Castle Doctrine in Montana is so extremely broad and liberal. It's in fact broader than most of the stand your ground statutes we have in other states. And I think the issue was really whether or not this guy was reasonable in fearing that a felony was about to take place in his house. Because in Montana, you don't have to fear imminent bodily harm or imminent death in order to use deadly force. You can shoot to kill if you believe that a felony is about to take place. And here we know the defendant was burglarized twice before this. He sees a strange individual entering his property in the middle of the night. I think it's entirely believable that he reasonably feared for his safety and the safety of his family, or at a minimum, that he was about to be burglarized again. So I was shocked by this verdict.
But Anahita, why didn't he just stay in his house? Call the police? I mean, he apparently had left the garage door open. They had baby monitors and other things to monitor the stuff, and he could look and see it. Just don't go out, don't go into the garage. Call the cops and don't bring out a shotgun and kill the 17-year-old kid.
Well, that's certainly the argument the prosecution made, and the jurors bought that argument, but the law in Montana does not require you to retreat. You don't have a duty to stay back and call the police. I mean, yes, this death could have probably been avoided had he done that, but he had no legal obligation to do that. He could use deadly force if he feared that a felony was about to take place in his home. And again, I think it was reasonable for him to suspect he was getting burglarized again.
Ashley, does this affect other type of stand your ground? Another case, another young man, Dzhokhar Tsarnaev, up in Boston, the suspected alleged Boston bomber, of course, from the marathon. Anahita, what do you expect will happen? I mean, the trial is set to begin, jury selection for Dzhokhar on January 5th.
Right. This is the last court appearance until the trial starts next month. And I think the big issue now for the defense is whether or not their client can get a fair trial in Boston. And they've already filed a motion with the judge asking that he move the trial to another state. The judge denied that motion, and they renewed that motion again today, and the judge still hasn't ruled. I personally think he can get a fair trial in Boston because the issue isn't whether or not these potential jurors have heard, read, seen anything about this case. You would probably be having to live under a rock not to have heard something about this case, but that's not the issue. The issue is whether or not those potential jurors can actually put aside anything they may have seen, read, or heard, that they can be impartial and they can make their decision based only on the facts and evidence presented to them in that courtroom. We've seen it work in other high-profile cases, and I think that it'll work here as well.
And Ashley, I mean, can the defense, do you think it could work if they claim just a few weeks away? And boy, oh boy, we'll be watching that. Anahita and Ashley, thank you so much for joining us today.
Thank you.
Thank you.